National trial attorney. Big case, Michael Jaafar is with me. Mike, great to see you. Thank you so much for being with me this afternoon. First and foremost, just want to remind our viewers it's a preliminary hearing. Basically, it's a low standard. They have to show probable cause that the crime was committed way, way far away from beyond a reasonable doubt. But defense attorneys like it. And they like it because they get information. We're watching an attorney here doing exactly that, getting information.
Yeah, absolutely. These are very, 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 when you first become an attorney in Michigan, your first day of training to be a public defender is about the preliminary examination, which I don't know why others did. When I was a young attorney, I thought every state had it. I guess not many. It's a very important hearing, and here's why. It could cut both ways. Many attorneys actually waive these, and they don't conduct them, and here's why. Whatever you elicit during that preliminary examination, you're stuck with that trial. So the theory is, if he asks questions at this hearing, and the person who answers them in a way where the attorney is not comfortable with, and that person, let's say, passes away before the trial, he's stuck with that testimony. And so it could cut both ways. It could cut in favor of you and against you. And if you notice, the defense did not bring any witness, right? They didn't bring any witness, and they wanted to examine the main person they wanted to examine was a deputy for the state, because they wanted to know what was a testing mechanism. Look, they only have one defense here. The defense, it's still a Hail Mary. Was the gabapentin in her system, and if it was, did that affect her legs and it prevent her from hitting the brakes? Because she clearly was driving in an assured distance. She was not passed out. And so were her legs affected? And so that attorney, Kalovis, I actually know him, he wanted to elicit whether or not the testing was done right, because the only defense they possibly have is the gabapentin in her system is what caused her to run into the boathouse, and not the alcohol. One more thing, Michael, Michigan is one of the few states. The legislature got sick and tired of people blowing the 0.08 blood alcohol level, so they passed a super drunk law. If you're 0.17 or higher, it's a different crime. And so for her, I think she's cooked because she's at a 0.18. I don't think the gabapentin will be a reasonable argument, but it's the only one they've got.